5 years ago, 17 recommendations were made to the Ontario government aimed at addressing the underrepresentation of Indigenous people on juries in this province. They were contained in a report which said, quote, "The justice system and juries process are in a state of crisis for Ontario's First Nations peoples." Joining us now on what impact those recommendations have had here and what they might offer to the rest of the country is the author of that report, Frank Iacobucci. Currently counsel of Tories LLP, he is a retired Justice of the Supreme Court of Canada, and we're pleased to have him here tonight. Welcome, sir.
Thank you.
And you actually said that you were here 5 years ago speaking to Steve about that report.
I believe so. Yes, I was, ma'am.
So back in 2011, why did the government of Ontario task you into looking into the issue of First Nations representation on juries?
Well, I believe the major reason was that there were cases going through the court system on concerns about the representativeness of the jury. And I think the government of the day felt it should, you know, this was something to be reviewed. So we spent a very intensive year, a small team I had, to get out in the communities. I visited a lot of reserves, particularly in the north, because that's where there is a lot of pressure on the justice system, and there isn't the usual support services that we see in the south of our province. So and that was really important because this was not just speaking to leaders of the communities. I did that, but trying to get into the communities directly and speaking to the people of those communities. And so, for example, I had a number of meetings, discussions that were in the Indigenous language, whether it be Ojibwe or Cree or OG Cree, and needed translation. Because the further north you go, you get more of an example of the language of the community is Indigenous, not English.
And in your report, you wrote that, quote, "Many First Nations people are plainly reluctant to participate in the jury system." Why is that?
Well, that's a very good question. And as I think I go into in the report, there are a lot of reasons for that. One of them that I knew a bit about, but I didn't realize how strongly held view it was within the communities, is that Indigenous people, First Nations in this case, really look upon our justice system as being somewhat alien. It's a cultural issue that they don't believe in judgment of people. Their preference is restorative justice, where they would get an alleged perpetrator, the victim, and the community sort of together and have that dialogue, that conversation, and work it out on a restorative basis.
How do we overcome that reluctance?
Well, that's a very good question also, because I think that isn't the only reason why there are not more Indigenous people on juries. We haven't done, I don't think we've done sufficiently well in educating them about our legal system. So there is something that's a challenge for us to do that, in the sense that we should try to get across the importance of what we believe the jury system's all about, that it has a long history. It's a very venerable institution, as everybody will acknowledge who knows something about it, and there's a good reason for it, and we should try to have that dialogue and conversation about our system, and there may be features, and there have been, there may be features of what they have done with their approach to misconduct that we could think about incorporating. And we've done a bit of that in the sort of looking at the sentencing circle when it comes to that. We've done, one of the judges up north, very, very, very conscientious judge, has an elder from one of the communities and sort of sitting with him to sort of give that judge an appreciation of the community in which the alleged misconduct took place and so on.
What action has been taken on your recommendations for making jury duty more inclusive of First Nations?
Well, I think there have been a number of developments and achievements that I commend both the committee, the advisory committee, and the government that responded to the recommendations and to the report. But let me mention there were structural recommendations. I thought it was important to have an advisory committee to the government, to the Attorney General, if you like, on the recommendations. That committee would have substantial representation from the First Nations. It was important to me to have that because when these reviews are done or when royal commissions are done, too often the reports just gather dust on the shelves. And I certainly didn't want that here. And having an implementation committee with stakeholders involved in advising gives them participation and gives an accountability, if you like, to the government to see, well, what are you doing with this report? And I think that largely worked. The government accepted the recommendations almost immediately.
Have any been impacted? I mean, enacted?
And they acted on the setting up of the committee. They went further than I did by having a majority of the members were from Indigenous people, backgrounds. They had co-chairs, one Indigenous and one non-Indigenous, a Deputy Grand Chief, Alan Fiddler, and a Assistant Deputy Attorney General, Erwin Glassberg. And that showed a commitment of senior people taking the assignment seriously. Then I also recommended, because of this feeling of alienation towards the justice system, another recommendation was to set up an advisory committee to the Attorney General on the relationship between Indigenous people and the justice system of Ontario. That was also done. And the third structural recommendation that I thought was important was that a recommendation to have someone in the senior officers of the Justice Department specially charged with dealing with Aboriginal or Indigenous issues in the justice system. And that was that recommendation was accepted, and they were fortunate to appoint a very impressive woman named Kim Murray, who has great experience. She was I think, executive director of the Truth and Reconciliation Commission. And she's been very, very active in following these kinds of issues.
Has the situation then improved in Ontario?
Well, it's an ongoing project, because if you're talking about educating people about our legal system and our finding out more about their approach to different things. So it's not going to be an overnight kind of achievement. It's ongoing, but I can only say I believe it has made considerable inroads in a number of ways, because you've got people who are committed, namely the Indigenous people are committed to this, and there are people in senior government positions who are also committed. So it's been a very, I think, promising start, but there's still much to do.
In the wake of the not guilty verdict for Gerald Stanley, who'd been charged with the murder of Colton Boushie, there's been strong criticism of the jury selection process. David Butt, a lawyer, writes in the Global Mail, when Crown and defense lawyers select jurors at the start of a case, each side has a number of peremptory challenges, a number that varies with the offense charged. These peremptory challenges allow each lawyer to automatically disqualify potential jurors, no reasons required. In this case, the defense used those peremptory challenges to eliminate anyone who looked Indigenous. The defense strategy was transparent, despicable, and it worked. Play the race card for tactical advantage. What purpose are peremptory challenges intended to serve in the jury selection process?
Well, let me just say right at the outset, Pam, I am not going to comment on the specifics of the Stanley case. I'm an ex-judge, I'm a traditionalist. This matter is before the courts, and I'm not going to...
And in your eyes, it's resolved.
However, I will say, number one, I have great respect for David Budd. No problem with that. But I am going to comment on what I said about peremptory challenges in the report. I did recommend that that advisory committee consider the matter of peremptory challenges because, to me, I believe that it is inappropriate to discriminate against someone on a racial basis in selection of jury. The whole purpose of my exercise was to get more representation of Indigenous people on juries in Ontario. And if all the effort is made to increase the roles, the jury roll, that's where you get the names of people randomly selected to be on the roll, and then these people are, there's a summons that goes out to come and be prepared to serve on a jury. And then if all that effort is done, and there's a lot of changes that are in the process of being done, but if they're going to be summarily dismissed on a basis because of their Indianness, that seems to me to be wrong and unacceptable in our society. And it's not only in our society, in the United States. Their Supreme Court in 1986 came up with a decision that said, look, to discriminate in jury selection, in this case on African Americans, was unconstitutional. It violates the Sixth Amendment of their Constitution. So I believe, and therefore recommended, that consideration be given to amending the criminal code. Now, the criminal code is a federal responsibility, so the province can't amend the code, but if the Attorney General was persuaded by the committee under the jury's report to bring that view to the federal government, then they could consider it. Now, no, I just said to use the peremptory challenge on a discriminatory basis. There are some people whom I respect who say peremptory challenges should be abolished. Full stop. And I respect that view.
What do you think? Well,
I think that there are arguments on both sides of the question. Because what is troublesome about what I recommended, is that if you just are looking to see the discriminatory exercise of the peremptory challenge, the judge is the person who has to make that determination. And there may be difficulties for the judge or in coming to that conclusion. So those people who see that as a difficulty advocate for the abolition of the peremptory challenge. There are those who think otherwise, and that gets to your question. What's the underlying rationale for having a peremptory challenge? I think it was said some years ago by the Law Commission of Canada that when someone is an accused in a criminal process, it would be fairer if that person could have some influence on the process by which he or she is going to be tried, and with the potential of the loss of liberty. And one way of recognizing that, so the accused could have some influence, is to give a peremptory challenge. And it's in some way recognizing the need for some comfort for the accused to sort of be subjected to a process that is affecting his liberty.
So should the challenges only be for the defense then?
No, it's for both sides. It is for both sides. It was given over time. Challenges came in, I think, around the 15th or 16th century in England. All of our criminal process, in its basic respects, came from England. But there was times when there were more advantages to the Crown, to the government side of the issue than there were to the accused.
I want to read another quote from David Butt, who I mentioned earlier, from that same piece. And he writes, "The sad reality here is that the jury's verdict is palpably unconvincing because Gerald Stanley and the jurors were white, because Colton Boushie was Indigenous, and because the trial was in a community plagued by a well-documented racist colonialist past. We can all easily doubt the integrity of the verdict." Do you think this trial is a spark that will lead to meaningful change in our legal system?
Well, again, and I don't want to get into the details of the case. There has obviously been, this has been an issue for some time, but it hasn't had the publicity that it has now. And I think let me just say this, I'm not going to resign in any way from what I recommended in the report. If it is the case that the matter should be dealt with even more broadly than I dealt with it, I wouldn't argue with that. But at the very minimum, we should not, in our legal system, tolerate a discrimination against people because of their color, their religion, and matters that are just fly in the face of equality and the dignity of each human being.
What do you think are the first steps to get from where we are to a system that is both fairer or seen to be fairer for Indigenous people?
Well, let me put it this way. I think the most important societal issue facing Canada is the relationship with our Indigenous people. I'm not a politician, but I'm entitled to have my own views, and that's my view. The more, and I begin with finding out more education for us about Indigenous people. I never read any of it in the history books that I was exposed to.
Same with me.
But I'm quite a senior citizen, so but I still think we have to be better educated, because we can't get into prescriptions of change without knowing a full diagnosis of what's involved. And the diagnosis to me is getting educated more about Indigenous people. I have been greatly educated by the work I've been privileged to do.
Thank you very much, sir, for being here. It's not every day that I get to speak to a justice of the Supreme Court of Canada, even though you're retired. We thank you for your time and your insight.
Thank you for having me.
Thank you.
The Agenda with Steve Paikin is brought to you by the Chartered Professional Accountants of Ontario, helping businesses stay on the right side of change with strategic thinking, insightful decisions, and business leadership. Are you on the right side of change? Ask an Ontario CPA.